Thank you for joining us for the WBC Preventing Claims of Harassment and Discrimination webinar. My name is Steve Kenton, and I work with Washington Building Congress. And it's my pleasure to introduce the program and our speaker today. Wanted to just briefly thank our Small Business Committee. They putting on this presentation, and Shauna Rothman, who is a colleague of our presenter at Smith Currie, was instrumental in putting this program together and bringing it to the attention of our committee. So thank you, Shauna, and thank you to the Small Business Committee. A couple of items regarding the presentation. We will be recording the presentation, and Josh has agreed to provide the PowerPoint slides to be posted on the WBC website. So we'll get that up this afternoon or tomorrow, so you can log into WBC's site and review the information if you would like to prior or following the presentation. There is a Q&A option that you'll have. So if you do have questions, please post those in the Q&A, and we'll get to those at the end of the presentation. If you have a pressing issue, I guess you could raise your hand, but we'd like to hold the questions and the answers till the end of the presentation. So with that, I will hand off the presentation to Josh Holt with Smith Currie. And thank you, Josh. We appreciate your time, and thank you for joining us.
Thank you, Steve. I appreciate that. Good afternoon, everyone. Thank you for joining us today. Let me also say thank you to Shauna Rothman for arranging this, and thank you to the WBC for inviting me here today to present on this topic. Steve mentioned, my name is Josh Holt. I am an associate at Smith, Currie and Hancock. I work in the Tyson's office. There we go. I've been with the firm for just over 3 years now. Before joining Smith Currie, I focused primarily on employment litigation. And actually, I had the opportunity to work for firms where I was representing both employees who were filing claims against their employers and management on the defensive side. So I have some insight into what each side of a dispute is looking for and what types of strategies they employ. At Smith Currie, I do obviously traditional construction law, but because of my background, I also represent our clients and help them with their employment-related needs. And a lot of that involves claims before the EEOC, which, is many of you know, is the Equal Employment Opportunity Commission. And it quickly became apparent to me when I was given my first EEOC claim to handle here at Smith Currie that employers in the construction industry, and obviously this is painting with a bit of a broad brush because there's a wide variety of types of companies within the industry, but particularly vulnerable to claims of harassment and discrimination, which is what the EEOC deals with. And at the same time, unfortunately, a lot of them are not particularly well suited, well set up for dealing with those types of claims, either in terms of preventing them, or if they, are unfortunate enough to have a complaint filed against them, to deal with it quickly and effectively. So that was somewhat of a gut feeling, and based on my individual claims with my clients. But I did also find information in the course of doing some work for one of my clients. This is from the EEOC's 2016 report that it prepared on study of harassment in the workplace. And it lists a number of risk factors, the first set being sort of the main ones and then some additional ones. And this really backed up my hunch. Several of these jump out right off the bat as being applicable to employers in the construction industry. And the report doesn't say that, but you can draw your own conclusions. So for example, you have homogeneous workforces, the construction industry being typically male dominated. That's obviously going to create some risk. Workforces with many young workers, that could also apply to specific companies. Isolated workspaces, that's obviously the case when you're dealing with job sites, and particularly when you have job sites spread out, multiple job sites going on at the same time. cultural and language differences in the workplace. Again, with construction industry employers employing a lot of members of minority groups, that's going to create some risk. And then decentralized workplaces. That's actually, I think, very important and a prime risk factor, as we'll sort of discuss throughout the presentation. It'll keep coming back. The reason that's important is because, again, when you're dealing with job sites that are spread out over a wide area, changing as projects start and stop, the management of the company doesn't have quite as much control over what's going on or even knowledge of what's going on at a job site, and it's constantly shifting. So that, again, sets construction industry companies apart from maybe your typical office environment. And so, and then, sorry, down into the additional risk factors, certainly workplaces where work is monotonous or consists of low intensity tasks certainly could apply at the more lower levels of a project, down with the less skilled labor. So right off the bat, that's 6 of the 10 that you're dealing with that pretty directly apply to construction industry employers. And it's also worth keeping in mind some of the factors in the current climate that apply to all employers. The first being the increased attention on discrimination and harassment that's happening due to things like the Me Too movement, the Black Lives Matter movement. And maybe something that's a little less on the nose is the burdens that dealing with COVID-19 is the burdens that's putting on employers and employees. So just generally speaking, you have increased tension as everyone's trying to manage this new environment we're working in. But you also have a lot of changes that are happening as a result. So hours being reduced, wages being reduced, and then certainly vaccines being a hot button issue that's going to create questions, going to create tensions within the workforce. When you're dealing with changes like that, just as a general matter, coming from the perspective of an employment litigator, that's a prime opportunity where you see a rise in claims of all types from employees. You may have employees who have been experiencing harassment or discrimination or really any other type of inappropriate behavior who may not be inclined to complain about it as long as they're working. They don't want to upset, rock the boat. They're happy to keep things going as long as they are getting a steady paycheck. Well, once you're cutting their hours, you're reducing their wages or even laying them off, the incentive to not report goes down. And in fact, they have more incentive to then try and recover something that maybe they were losing, try and get some money out of the company and get some compensation for what they've been going through. And just generally, as things are changing, there are a lot of decisions being made about where people can work, what they need to do, trying to manage all these additional burdens imposed by COVID. And the more decisions you have being made, again, the greater the risk that some of those decisions will be made in inappropriate ways. So what I wanted to do in this presentation is to just put together some general guidance for construction industry employers on ways to avoid harassment and discrimination claims. Based on what I've seen from clients, that things that they've done well and things that they've done not so well. So lessons learned from my own experience. And the main thing that I want to impart on everyone is that you do not want to be the target of an EEOC complaint. And that's obviously, pretty self-apparent. You don't want to be facing any sort of liability of any type. From a personal standpoint, obviously, if you have an employee who's complaining about harassment or discrimination, that's a problem, and that's something that everyone should care about, just in the sense of wanting to make sure that your employees are being taken care of properly. But from the company's perspective, from a liability standpoint, resolving a complaint with the EEOC, even successfully, can be fairly costly, as we'll talk about. But the bigger point that I'm trying to make with this takeaway number one is that because of the way the EEOC works and the discrimination laws function, a complaint can pretty quickly open the door to further complaints. So what starts as one complaint can quickly turn into 2 and 3. And just by way of an anecdotal example, I have a client that's fairly typical, I think, of a construction industry employer. It's a subcontractor in the area, and they've been operating for years without any issues from the EEOC, without any known complaints about harassment or discrimination. And a couple of years ago, they received a notice that one of their employees had filed a complaint. So we worked through the process. It took several months. It was costly and fairly disruptive to the company. And ultimately, we were able to settle it. But of course, that required the company to pay a certain amount of compensation to the employee. They had to implement certain procedures. They had to do things that required spending money without directly paying it to the employee. So implementing training programs, things like that. And while we're negotiating the final terms of the settlement agreement, we received notification that there was another complaint. Well, the client was understandably frustrated because here they had had a clean sheet essentially for several years, and all of a sudden they now have 2 complaints. And in fact, there's the potential for more. So the reason this happened, in assessing, taking a step back, is that they weren't well set up to A, prevent the claim in the first place, and B, to handle it appropriately. They had, for example, a standard equal employment provision that they had copied and pasted into their employee handbook and set it aside and never revisited it again. They didn't do training. They had very informal policies about the way things were handled just on a day-to-day basis. So we are now in the process of trying to build up the infrastructure in order to help the company avoid future claims, but we are essentially building the airplane mid-flight as we're going through. And of course, we're already subject to complaints, and it's a very reactive process. So the lesson I want to impart is that you don't want to wait until a claim comes in. You want to be proactive. Everyone thinks that it won't happen, and then when it does, the ball is already in motion, and your hands are tied. There's much less you can do about it. And the second takeaway is that the best way to avoid an EEOC complaint is to establish a healthy workplace culture. Sometimes I think these presentations about harassment and discrimination can come across as a little tone deaf, particularly, you have a white male lawyer talking to management, people who make decisions for companies out there about how to manage liability and risk. And it sort of ignores the human aspect of what's going on. And then we're talking about people who may experience severely traumatic situations. But this is not about avoiding liability, it's about preventing liability. So the point that I'm trying to get across in this, and that we'll discuss in more detail, is that you want to get out ahead of it. You want to establish a healthy workplace culture, because that enables you to prevent claims from happening in the first place. And then if for some reason a complaint arises anyway, because it's impossible to completely rule it out, and of course there's always the potential for misunderstandings or for someone who is just intent on bringing a complaint, it allows you to respond more effectively and then help ensure that it's a one-time event instead of much more. So quickly before we get into the discussion of what you can do, I do want to go over a bit of background because it does inform the discussion and it underscores the points about why you want to avoid an EEOC complaint in the first place, and then how you go about doing that. So what is the EEOC? Simply put, it's the federal agency that is responsible for enforcing federal anti-discrimination laws that deal with employment. And when we're talking about those, it's Title VII of the Civil Rights Act. You have the Equal Pay Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, or the ADA, and a recent law called the Genetic Information Non-Discrimination Act. Collectively, these laws make it illegal to discriminate against either a job applicant or a current employee because of a number of factors, those being race, color, religion, sex, which includes pregnancy, gender identity, and sexual orientation, national origin, age, which is for workers who are 40 or older, disability, or genetic information. And these laws generally apply to employers with 15 or more employees, so that's the threshold. I included the point that it's not included independent contractors because it's worth knowing, except that you need to be very careful about relying on formal classifications. Misclassification is a very hot button issue right now, as I'm sure many of you know. So it's a presentation for another day, but that's certainly something to be aware of. Just because someone is called an independent contractor does not make them an independent contractor in the eyes of the law or the EEOC in this case. It's really about what the person is actually doing. So don't give too much credence to the labels if you're trying to decide whether or not the laws apply or not. And this is an important point, is that the laws deal with discrimination, but the courts have said that harassment is considered a form of discrimination. So it's somewhat of an awkward fit because really when you're talking about harassment and discrimination, it's somewhat two different animals, and there's certainly different types of complaints, but they all fall under the same category. You know, I'll single out as we go forward where a point that I'm trying to make applies a little more to one than the other, but generally speaking, the 10 things that I'm going to be walking through will help with both. And just to close the circle, harassment typically falls into two categories. There's one which is quid pro quo, which is where you have the exchanging of favors, and then hostile environment, which is more along the lines of comments, pictures, things of that nature that generally create an environment that the law considers harassing to an individual. And another important point is that the law not only prohibits discrimination and harassment, but it also prohibits employers from retaliating against employees or job applicants for attempting to assert their rights to be free of harassment and discrimination. And so, for example, that would include asking questions to uncover a potential discrimination claim, resisting sexual advances when it comes to harassment, filing a complaint, and cooperating in investigation. And the reason that's important to note is because it essentially establishes an extra layer of potential liability, where you would have a harassment claim or discrimination claim. And if you haven't handled it right, then you're opening yourself up to essentially a second claim, which is that there was some action taken against the person complaining because they were complaining, and therefore you're facing additional liability. And part of the reason I bring all this up is because all of the laws, except for the Equal Pay Act, require an employee to file a complaint with the EEOC first. So the EEOC is the gatekeeper. An employee cannot file a private lawsuit until they filed a complaint with the EEOC. So when you're dealing with any claims of discrimination or harassment or retaliation, the EEOC is going to be the first entity you interact with. And quickly, again, because it does establish what we're going to be talking about, I want to walk through the process that the EEOC uses for investigating and attempting to resolve a complaint. If you've never been a part of it, it's not something that you would necessarily know much about, and it is different from traditional litigation. So it all starts with an employee filing a charge of discrimination. As I said, that's the mandatory step before the employee can file suit. It's a one-page document. Oftentimes, the employee can make a stronger case, but they really don't have to. I've seen charges that are ambiguous at best about who was involved and what actually was done. And so you're receiving it and you have very little to go on at the outset, except to know that the individual employee is complaining about harassment or discrimination or retaliation. And just timing wise, there's a 300-day cutoff in many states, and that's if the state itself has a agency and a set of laws that essentially cover the conduct in question, and 180 days in all other states. Just something to be aware of. So the first thing the EEOC will do is notify the employer of the charge. And they invite the employer to submit a position statement. And the reason I wanted to highlight this fact is that it's really the employer's primary opportunity to respond to the allegations of the charge. And it's done almost right at the outset of the complaint process. So you very likely have just the charge to go on, and you have to respond to it. And it's potentially the main opportunity you have to respond. It's possible to effectively respond, and it is possible that your response will convince the EEOC to dismiss the complaint, but you really need to be prepared ahead of time in order to do that. So that feeds into what some of the things we're going to talk about, which is how to be set up for success when the complaint comes in so that you're already primed for your position statement. I also noted that the EEOC may invite the employer to engage in mediation, although that hasn't been my experience for the most part. I don't know if that's a specific type of claim that might, in which that might occur, but typically you go right into the next step, which is the EEOC investigating the charge. And one important thing to note about this is that it can be a lengthy process. And part of that is up to the employer, depending on how long they take to provide the information that the EEOC is looking for. But also the EEOC, will take its time reviewing the information. And typically the investigation consists of requests for information from the employer. This somewhat similar to document requests or interrogatories for anyone who's been engaged in litigation in court. So they might ask for employment policies. It will almost certainly ask for the personnel files of anyone who's involved, both the victim and the alleged harasser or the person who made the decision. They're going to want to see any records of internal investigations that have been performed. They may ask for employment statistics, particularly if you're dealing with a discrimination claim, because they want to assess the the makeup of the workforce. And they may ask just direct questions about what happened and what's alleged to have happened. And the second big part of the investigation is that the EEOC will conduct interviews. And obviously they're going to speak to the victim, the person who's involved in any of the decisions or any of the actions. They may want to speak to witnesses and other employees as well. And something to keep in mind is that if they are speaking to someone who's not a member of management, at least in my experience, they will not give you a heads up that it's coming, and they do not feel obligated to have anyone from management present, or certainly legal representation. So this is happening on the side, and you have very little control over what's being discussed. After the investigation, the EEOC makes what's called a reasonable cause determination. If they determine that there's insufficient support for the claim, and again, this could happen in response to the position statement, so it can happen fairly early, but that would be as a result of a very effective position statement. If they determine there's insufficient grounds, they issue what's called a right to sue letter to the employee, which tells the employee, okay, we've looked at the complaint, we're not going to pursue it, and the employee then can file their own lawsuit. This does not mean that the claim has no merit, and in fact, in my experience working on the plaintiff side of things, representing employees, this is somewhat of a formality for the plaintiff's bar, where they file the complaint and their goal is really to get that right to sue letter so that they can take off and pursue the private litigation. Obviously, the lawyers have their own incentives in doing that, but it's just an administrative hurdle. So it doesn't mean you're out of the woods. And certainly it suggests that the claim isn't something that the EEOC is going to spend time on, because it either doesn't want to spend as much time as it would take to prove it, or maybe it thinks there's something missing in the claim. But again, the employee can file a claim, and from the plaintiff's perspective, there is a certain value in having that. So even if it's a non-meritorious claim, there's a certain nuisance value in filing suit against an employer, and you may be able to settle for a certain amount of money or get something more from the employer. On the other side, if the EEOC determines that there is reasonable cause to believe that something has happened, that the employee's claim has merit, they will issue what's called a letter of determination. And similar to the initial charge, there's very little information provided here. So one theme in the EEOC's processing of these complaints is that it's very lacking in transparency. So it's incumbent upon the employer to essentially do the work on its own, and again, do the work ahead of time in order to be able to properly respond, because otherwise you're dealing with somewhat of a black box. And the next step, well, the EEOC will offer the employer a chance to conciliate, which means settlement. They call it the conciliation process. And the employer can decline, which skips right to the next step. But if you choose to engage, at least in discussions with the EEOC, you then move into what's called the conciliation process. And one of the things I want to flag about this is that, in my experience, at least, the EEOC has sort of a standard proposal that it puts forward, and it includes some combination of money for the complaining party. They often want to see the employer engage in training in order to deal with whatever the alleged problem was. And importantly, which we'll touch on a bit later, they also impose monitoring requirements. So this the settlement agreement will say something like, this settlement agreement will remain in place for a number of years, and it, will specify. And during that time, the EEOC can check in on the employer, and it may actually require the employer to provide regular reports. So obviously the parties will negotiate the terms. You can push back, you can get, offer less money, press for a shorter time period, less burdensome training, things like that, but it's a typical negotiation. So you often arrive somewhere in the middle. If you're able to agree upon the terms, then the matter is resolved. The employee releases the claims, and everyone moves forward. If not, or if the conciliation process falls apart, or if you decline to conciliate, then the question becomes whether the EEOC will pursue litigation. And I've seen statistics that the EEOC really only pursues litigation on its own around 8% of the time. But you have to remember that if the EEOC declines to pursue litigation, then you're back to the stage where they give the employee the opportunity to pursue litigation on their own. So circling back to what we were talking about at the outset, the reasons you want to avoid an EEOC complaint in the first place is first because it can be costly to resolve. You have the money that you may have to pay to the employee as compensation. And I should note that that may include straight compensation in terms of any unpaid wages, particularly if you're talking about a discrimination claim. It may also include emotional distress damages. So that could start adding up, and it's difficult to quantify. So it's difficult to push back on what the EEOC asks for in that respect. You also have legal fees, obviously. If you've undertaken a full process of fighting back against the complaint, that can really start to add up. You also have the fact that the investigation process, like I said, can last several months. And in that time, your employees are being asked to provide statements, or they're being interviewed. And generally, that's just going to be disruptive to your operations. And you also have the fact that you now have an employee who has complained about harassment, other employees who are being asked about harassment, and generally you have the negative effect on employee morale. And then of course you also have the reputational harm of being sued for harassment or discrimination. But again, the bigger point that I was trying to underscore is that one claim can quickly turn into multiple claims. And there's a couple of different reasons for this. The first being that you have now effectively opened up the possibility to other employees that filing a complaint with the EEOC is an option. And the cynical perspective on that is you've shown employees who are inclined to pursue this option that they can file a one-page complaint and potentially get a sizable settlement out of the company. And this all ties back into the fact that this is not traditional litigation. This is the EEOC investigating, not providing much information, holding all the cards in terms of negotiating a resolution. And actually that reminds me, one of the things to bear in mind with the negotiation that can be difficult, again, you're negotiating a settlement without really knowing what information the EEOC has. So they're not disclosing what information they use to determine that there was reasonable cause to believe that the complaint is valid. They've just told you, we think there's something here. And in my experience, at least, you're negotiating with a EEOC investigator who's not actually making the decisions, about the resolution of the complaint. So they're essentially acting as a go-between. So not only are you operating without full information, but you don't even have a direct line of communication to the decision makers. You really just working with someone who will pass along your argument for why maybe the damages are too high, but has no authority to make any decisions based on that. The second general reason why you might end up with multiple claims is just that the company is now on the EEOC's radar. So, there are hundreds of thousands of employers around the country, and the EEOC has limited resources. And so being known to them means that they now have their sights set on you. You're now known among their list of employers who have potential problems that need to be addressed. Aside from the general knowledge of the company as a potential problem, you also have the fact that during the investigation process, it's entirely likely that the EEOC investigator, in speaking with other employees, is going to be asking about other issues that may have arisen. They may ask the employee, have you experienced any harassment or discrimination? Are you aware of anyone else who may have experienced any harassment or discrimination? So you're essentially opening up the doors for the EEOC to come in and just start looking around and seeing what can be found. And it's important that that may also include other things that maybe hadn't been the subject of the original complaint, but in the process of the EEOC's investigation, they learned that there's someone else who has a different type of complaint, and they're not going to just turn a blind eye to that. And finally, as I said before, the company may be subject to self-reporting requirements, or the EEOC may have an exact monitoring requirement in the conciliation agreement. So for example, in the conciliation agreements that I've dealt with, there's typically a provision that basically says that the company will not engage in any further acts of discrimination or harassment. And in order to confirm that, the EEOC reserves the right to monitor the company's operations for a period of time. And that may include requiring written reports from the company. They may be allowed to inspect the company's records, or certainly interview the company's employees. And another thing that the EEOC often insists on is a reporting requirement, where they may actually require the company to hire a third party to serve as a neutral investigator for any complaints that come up. And as part of that, they require, at least in my experience, regular reports on whether any additional complaints have been filed. And this includes not only complaints directly that would lead to the EEOC, but informal complaints. So the ombudsman, as they're called, is required to field any complaints, and the employer is required to notify its employees of the presence of this person and the fact that they may be available for any complaints. And then on a quarterly or regular basis, the company has to provide any complaints that have been given to the ombudsman, has to report those to the EEOC. So of course, that is very likely to lead to additional investigations and possibly more complaints. So as expensive as it is to deal with a single complaint, obviously you don't want to deal with multiple complaints, and opening up the door to one complaint quickly turns into 2 or 3 or however many. So what can you do to prevent claims? I put together 10 recommendations that I think will help both prevent claims from arising in the first place and, again, set you up to handle a complaint quickly and effectively in order to cut off the possibility of repeat complaints. So the first one is know your workforce. And again, this is a little bit self-explanatory or maybe obvious. But the idea is really to perform a self-assessment of the risks that exist within your workforce. So for example, what is the general makeup of your workforce? Is there a disproportionate number of one protected group or another? For example, do you have, is your workforce overly dominated by men? Do you have a small group of women within your workforce? And then related to that, how does that break down by position? Because of course it's a problem if you have an underrepresented group, but if they are also confined to a single low-level position, then that's an additional problem. And that's also creates the possibility of self-reinforcing discrimination or harassment, because then you have, for example, say you have a small group of women within your workforce. If they're not in a position to make decisions for the company, then it's very likely the decisions are just going to reinforce that disparity in the number of women who work in the company, and may lead to discriminatory practices, because obviously you're not getting the input of all of the groups within the company. How are benefits distributed? By this, I mean, who's paid what? Certainly it's a problem if one group is being paid at a different rate. It's definitely a problem if you have people within the same position being paid different rates based on being paid different rates that correspond to their status within a group. Do any employees require accommodations? That goes directly to something like the ADA. You need to know if you have employees who need special accommodations because of a disability or some other condition, and whether that's being met. And then more along the lines of harassment, you really just want to know who your employees are. Obviously, you can't tell when someone is more disposed towards harassing behavior, but you need to know how people are being brought into your company. Is it based on referrals? Are they being put through formal application process, or are they just being brought in on a temporary basis to work for the company? Again, this is a problem, circling back to the point about decentralized workforces. If the workforce is constantly shifting and constantly being moved around, it's much more important that you be on top of who is working where, with who, and again, what the makeup is of any particular job site. And then you also want to think about subcontractors, because the courts have held that a general contractor can be responsible for the employees of its subcontractors. This will depend on the relationship, obviously, because if you have a subcontractor who's doing discrete work and their employees are all working together and there's no interrelationship, then that's a separate employer. But if you're bringing in subcontractors who are working under the supervision of your employees, then that creates the possibility that they will be seen as acting on behalf of your company and could impart liability to your company for their actions. And in this sense, it's actually worth noting in Virginia, where I practice primarily, there was a recent law that actually says that for purposes of wage claims, a general contractor is in fact considered to be the employer of its subcontractors' employees. So if there are wage issues having to deal with a subcontractor's employees, the liability can flow all the way up to the general contractor. And that's limited to wage claims, as I said, but it's this general idea that the general contractor or even a subcontractor, if there are lower tier subcontractors, you have to be aware of who's working under your supervision. The goal of this idea of just having a sense of your workforce is to be able, again, to address problems proactively. Obviously, you can't address a problem until you know it is a problem. So you want to know where are the risks, what things can be done to address them before they become a problem. Do you need to change your hiring practices to encourage more people of one group to apply for jobs? Do you need to do outreach to attract people of a particular group? Do you need to revise the policies or the hiring practices that are weeding out people from a certain group? All those can help you proactively address potential problems. And again, it allows you to effectively respond in the event that a complaint comes in. So as I said, the position statement is something that the employer is permitted an opportunity to do very early in the investigation process. So the more you know about what your workforce looks like, particularly in regard to discrimination claims, the more effectively you can respond and potentially resolve the claim right at the outset. So just by way of an example, in my own experience, before coming to Smith Currie, I handled an EEOC complaint for a large retail company. And actually, it was a couple complaints where terminated employees alleged that they were terminated or passed over for opportunities earlier in their employment because of their race. We were able to actually get the claim resolved right at the outset with an effective position statement, because we were able to provide statistics about the makeup of the company, how people of that race were fitted in at various positions, showed that they were actually in positions of authority. So there was, to undercut the argument of any sort of bias against people of that race. And then importantly, we had well-documented personnel files for all the employees who were complaining to show that the termination was actually completely justified. It had nothing to do with race. These were people who had been disciplined on multiple times and given, a third strike warning, and then they had a third strike, and that's what the termination was for. So we submitted a position statement. The EEOC declined to take it up. And actually, there was no follow-up litigation because we had so effectively responded to the allegations. The second point is to establish clear, robust anti-discrimination policies. And this is about setting the tone of what you expect from your employees and making it clear that discrimination, harassment, retaliation will not be tolerated. So typically you want to include at least, a description of the type of behavior that's not tolerated. So it's not just a generic prohibition on discrimination or harassment. You want to make clear what the consequences will be for anyone who is found to have engaged in that behavior. You want to outline the reporting process so that employees know what they can do, and also they know that there is a clear way that people who are victims can elevate the complaint to management. And you want to provide a description of the investigation process. And importantly, this really ought to be tailored to your company. As I said, you can get an equal employment or an anti-discrimination policy. You can download one and copy and paste it into your employee handbook, but it won't be effective if it doesn't fit your company in terms of, for example, the reporting process. If it doesn't outline who the employees should go to, and that is a specific job title or a specific person in your company, then it's not going to have the same effect. And you want to make the policies widely available. You want it to be well known to your employees what's prohibited and what can be done and what will be done if there's any sort of improper conduct. So you want to put it in the employee handbook, as I mentioned, and you want that handbook to be part of the work experience and not just something that someone's given at the outset of their employment and never looks at again. And you certainly want to post it in well-visible places at any offices, and certainly as you change job sites, it should be reposted and made obvious to anyone who wants to see it. The third recommendation is to establish clear and objective employment policies. And this is different than the anti-discrimination policy. By this, I mean the general policies that dictate decisions that are made on a day-to-day basis. So hiring decisions, requests for time off, requests for transfers, pay raises, and termination. The more these decisions are made based on neutral criteria, the less risk there is. Because when you allow these decisions to be made on an individual basis, based on personal feedback, you create risk for not only discrimination, because the decisions can be made based on improper factors, and actually you also create the risk of harassment on a quid pro quo basis, because you have, for example, people who are now in a position to offer favors or benefits to other employees because they have the authority to offer time off or offer a pay raise that isn't bound by any objective criteria. And that feeds into the other point, which is that those decisions should be made or at least reviewed at a upper management level, which ensures a degree of consistency, but it also ensures that there is review of those decisions and they aren't being left completely in the field. The fourth point I want to underscore is you actually have to train your employees on the policies. Obviously, it's not enough to have the policies written. The employees have to know how they work in practice. And that goes for both the day-to-day policies, the policies on day-to-day decisions, and the anti-discrimination policies. You have to educate your employees on what constitutes unacceptable behavior, because there's quite a bit of gray area when it comes to what constitutes harassment, what constitutes discrimination. It's really a spectrum, and there's a line, and once you cross that line, that's when you get into trouble. And you can't assume that everyone knows where that line is, and certainly not in all situations. So it's also helpful that the training include actual examples. Again, as with the policies, this can't be a one-size-fits-all training that's just generic to employers across the board. You should provide actual examples and whenever possible, have it be interactive, where the employees are actually forced to engage in decision-making and deal with sample scenarios. And those should be based on the specifics of your workplace, so that they understand and can apply those lessons when they go back into the workplace, and it's not some generic description of what happens in a broad category of situations. And importantly, this is something that's overlooked a lot. It should be repeated and reinforced on a regular basis. And if at all possible, modified periodically so that you avoid a situation where you have an employee just has to sit down for the same training that they've done every other year for the past 5 years and they zone out. Number 5 has to do with specifically training your managers on recognizing and responding to problems. And this is based on the idea that your mid-level managers are the first line of defense. They are the ones who are actually implementing the policies that you've put together, and they're the ones who are interacting with your employees on a day-to-day basis. So they're receiving complaints or they are seeing things happening in the field, and they have the ability then to, if they recognize a problem, they can step in and stop it before it gets to a place that might lead to a complaint. And if at all possible, a helpful way to reinforce this responsibility is to actually make it part of their job duties and include it in any assessments that are done of the employees. How effectively are they handling this responsibility? Are they recognizing these problems? If problems have arisen that got past someone's notice, that's obviously something that should be addressed in any sort of yearly or other review. 6, 7, and 8 are deeper dives into what I already mentioned about the anti-discrimination policies, things that should be a part of that. So the first being to establish the clear reporting structures. The idea is you want your employees to know who they should go to if they have a problem, if they experience something or if they witness something. And you actually want to make it clear that there are multiple avenues for reporting, because obviously you don't want an employee who is complaining about the way their manager is treating them having to go to the manager to complain about it. So there ideally should be maybe a neutral person outside of the chain of command who can field these types of complaints. And in the policy, you want to assure your employees that first, the complaints will be taken seriously, that the information will be confidential, and that there will be no retaliation for asserting complaints. The idea basically being to encourage open communication. And on a certain level, this is a little counterintuitive because you don't want to invite complaints. But at the same time, if a complaint exists, you want to know about it. This is also a little more on the side of responding to complaints and cutting them off early as opposed to preventing it. Except there is also a degree to which having these clear reporting structures in place can serve a deterrent effect. And again, this is something that you want to be in your policy so that it's clear to everyone. If the employees know that certain behavior won't be tolerated and that there is a way for people to quickly report it, they may be a little more careful about what they do. This also allows you to address the problems internally as opposed to allowing it to go outside to the EEOC. That's obviously one of the goals. If you have complaints and it's bound to happen, you want to be able to handle them instead of having to respond to the EEOC coming in and again, opening the doors to everything. So again, an example, my client who had to appoint the neutral party to field complaints, the first thing that happened is all of a sudden the ombudsman started fielding complaints from employees who just clearly had a lot of things to complain about. And they really weren't quite at the level of creating problems for the company. It was just kind of smaller complaints. And both the client and the ombudsman started getting frustrated that all of a sudden these employees were bending their ear about these problems. But it's much preferable to have that coming to someone within the company than having that person go outside and bring in the EEOC. And a lot of times you'll have employees who really just want to be able to tell someone about the problem. And if they don't have someone within the company who's going to listen, they might go looking for someone else outside the company who's going to listen. And again, if I haven't already mentioned it, you can handle the problems internally, but having the reporting structures in place means you can handle them quickly and potentially cut them off early before they become something bigger. So if someone starts complaining about the way they're being treated, that can be addressed right then, and maybe it won't become a problem. If it's not reported internally, then it could spiral out of control. So number 7, related to that, and again, something that's should be upfront in the policy, is to establish an investigative process. And part of the goal behind this is that you want to be prepared when a complaint comes in. And I'm not referring to necessarily EEOC complaints, just reports of inappropriate behavior, so that you can respond quickly. Because again, having that process in place may deter behavior. It allows you to respond to it and deal with it internally and cut it off before it becomes a bigger problem. But also bear in mind that if you have the process laid out before the complaint comes in, you don't have to make it up as you go along. You've got everything in place, you know how it's handled. And this is important for avoiding potential problems that could lead to retaliation claims in the future. So for example, one of the obvious solutions, if you have multiple work sites and you have an employee come in and saying, my foreman at this work site is treating me inappropriately, is to move that person to a different work site. But that could give rise to a retaliation claim. So you want to have thought through what you do with the people who complain, the people who are complained about, how you handle it in the meantime, so that you're not just kind of making up as you go along. And ideally, again, as with the reporting, this should be led by someone outside of the chain of command, so that you're not in a situation where the person who might be implicated in the complaint is involved in the investigation. And circling back to a point I raised earlier, the more you do up front, the more effective your investigative process is, the better equipped you are if the complaint ends up going to the EEOC for whatever reason. You've already marshaled all of your evidence that you need for the position statement, and you might actually be able to put up an effective defense. And number 8, again, right in the employee handbook, you want to have established what the discipline is for inappropriate behavior. You want to, again, this is about setting the tone, letting people know that there will be consequences for inappropriate behavior. And as with any sort of discipline, part of the key is in actually applying it. So it's not enough to have just said, here's what might be the consequences if you engage in this behavior. You actually have to go through with it. The 9th bit of advice I have for dealing with these types of complaints is to document everything. So before a complaint comes in, you want to have kept track of everything relating to a particular employee and employment, your workforce in general. So pay rates, job assignments, you certainly want to keep track of any requests that were made and responses in terms of benefits, time off, raises, requests for accommodations, certainly. You want to keep track of which employees have been attending the training that you have been hopefully implementing. You want performance evaluations, and you certainly want to keep track of any disciplinary actions. This goes back to the point I was making about being able to show, particularly in a discrimination complaint, that there were genuine reasons for any action taken against the employee, or a claim that there's a disproportionate or a disparate effect on certain types of people just doesn't bear out. That person may feel that, but you have a good balance of people among your workforce and at different job assignments and receiving a certain pay rate. You want to be able to respond effectively. After the complaint comes in, if it does, you want to document what exactly was done to investigate, what was determined as a result of that investigation, and what action was taken. And this also goes to the position statement, because ideally you want to be able to respond by, if there is merit to the complaint, you want to be able to say to the EEOC, we fielded the complaint, we investigated it, we took the following action as a result, and therefore the matter is in hand and there's nothing more to be done. And finally, just bringing it all back, you want to reassess your policies and practices on a regular basis. That should be part of maybe a yearly process, is to go through the practices, go through the policies, reassess them, update them, whatever's necessary. Certainly, if you field a complaint internally or externally from the EEOC, you want to do a bit of a debrief in terms of what happened, what could have been done differently, what was done well, and what needs to happen the next time. The idea is to get a sense of what's working and what's not. And then, of course, you want to actually make the necessary updates to your policies, processes, and training. The idea being that, you want to, if you can, prevent any claims from coming in based on what you've seen so far. And if something has happened, you want to cut it off so it doesn't spiral out of control. So those are my 10 recommendations on what you can do to prevent claims of harassment and discrimination. Here's my contact information. If you have any questions, I certainly would be happy to help you in any way that I can, answer any questions you have. And if you have questions right now, I'd be happy to get to those as well.
Josh, we do have one question posted in the chat, and that is, are you seeing discrimination, wrongful termination, or other claims from the EEOC related to the COVID vaccine mandate?
Yeah. I can't speak to what the EEOC is seeing. I wouldn't be surprised if they're seeing a lot. The EEOC was actually the first to really come out quickly with guidance on how to handle the vaccine mandates. And it was less than clear, but the general takeaway was that employers can mandate vaccines without running afoul of the anti-discrimination statutes. The only exceptions being people who have religious objections to the vaccine and people who have medical conditions that would fall under the ADA that would prevent them from taking the vaccines. So that's a fairly limited set of situations. Obviously, I think anecdotally in the news, I've seen a lot of people pushing back on vaccine mandates on the basis that it violates their religious beliefs. I don't know the degree to which that's been elevated to the EEOC. So I can't really speak to that. It's a really interesting question though. And I think something that's going to become, it's probably going to be something that's, litigated very heavily in the coming months and years.
All right. Go ahead.
Oh, go ahead.
Well, there was another question posted. Actually, another couple popped up. Does the EEOC have a current backlog of cases?
I don't know if it's a backlog. They're certainly very busy. The one client where one claim turned into multiple claims, I have gotten to know the investigator fairly well on a first name basis. And I have asked her some questions generally just to try and get some general advice, some feedback from her based on what they're seeing. And she's referenced the fact, she handles hundreds of cases at a time, in a given year. They move pretty quickly though. So, if the question is, is there going to be a delay or maybe they'll defer some sort of enforcement? I'd say the answer is no. The complaint goes in and then they're knocking at your door, letting you know the complaint goes in and then investigating it. It would play into the length of the investigation, certainly. They don't move very quickly. And so that would certainly, again, add to the cost, add to the disruptive element to having an investigation, just because it can be a really long process.
Right. We have another question. Do you have any recommendations on purchasing employment practices liability insurance policies?
That's a little bit, I don't have any general recommendations. That's a little bit, outside of my scope. Not to punt, but it does depend on the level of risk in your particular situation, and whether it's worth having that added layer of insurance.
Well, excellent. Those are the questions that were posted. Unless anything else pops up, Josh, thank you very much for your time and for a great presentation. And thank you everyone for joining us. And as I mentioned, we will post the recorded presentation and PowerPoint slides online. So once again, thank you to everyone and have a great day.
Thank you. I really appreciate it.